Dear students, viewers and the subscribers, welcome to the IAS Mentor. This would be our lecture number 121 in the series Indian Polity. So today we are going to see a simple topic, but again a very effective topic. Why I am saying this is UPSC every year there is asking one question from this particular area, that is the schedules to the Constitution of India. If you see the schedules to the Constitution of India, there are 12 schedules in the Constitution, right from schedule number 1 to schedule 12 of the Constitution. And in the original Constitution, there are only 8 schedules, and subsequent to the commencement of the Constitution, 4 schedules were inserted. So as we'll proceed in this particular topic, we'll try to understand what is a schedule, what are the subject matters of various schedule, what are the schedules that is amended after the commencement of the Constitution. So these are all the things that we'll try to understand. There are few schedules that has been repeatedly asked year after year in the UPSC examination. For example, 5th schedule and 6th schedule, schedule 10 of the Constitution, schedule 9 of the Constitution, schedule 8 of the Constitution. So these are all some of the schedules which UPSC focuses upon and they ask it. But apart from that, any schedule at any point of time can be asked in the examination. Not only in the UPSC examination, but also in the other competitive examination. So let us give some time, probably half an hour, and we'll try to learn about these schedules. And even if you watch this particular lecture, you will be able to solve the questions that can come in the examination. So first of all, what is a schedule? So what does it mean by schedule? The schedules are nothing but an appendix. If you read any particular textbook or if you read certain documents, that in any financial documents also, you can see that the main subject matter will be there and any tables or any appendix will be put in the end. So this is for easy organization, so that the organization of the document is done properly. So similarly in the Constitution, what they have done is, while there are specific articles which deals with a particular subject matter, but if they want to give elaborate data related to that, or if they want to provide any information related to that, they have arranged in a specific schedule in the Constitution. So therefore, the schedules are nothing but they are just like an appendix to a textbook. And these schedules do come from a particular article in the Constitution. So for every schedule, there is a source article. For example, Schedule 1 of the Constitution flows from Article 1 of the Constitution. Schedule 9 of the Constitution flows from Article 31B of the Constitution. So Schedule 10 of the Constitution comes from Article 102 and Article 191 of the Constitution. So there is a source article. But whatever the subject matter of that particular article, any extra information is separately given as a schedule to the Constitution of India. Now here we are going to consider what is given in each and every schedule. So that is our primary focus. And how many schedules do we have today? Today we have got what is called as 12 schedules in the Constitution. I already said that. Of these 12 schedules in the Constitution, 8 schedules were there in the original Constitution. Schedule 9, Schedule 10, Schedule 11, Schedule 12, they are inserted by the various constitutional amendments subsequent to the commencement of the Constitution. For example, Schedule 9 was inserted by the first Constitutional Amendment Act. Schedule 10 was inserted by the 52nd Constitutional Amendment Act in 1985. Schedule 11 and Schedule 12 were inserted by the 73rd and 74th Constitutional Amendment Act in 1992. Sometimes this itself can be asked as a question. So try to remember that. Alright, so with that basic information, now let us get inside. Let us try to understand as to what is the subject matter of each and every schedule. So let us first try to understand Schedule 1 of the Constitution as to what is the subject matter of Schedule 1 of the Constitution. Now the subject matter of the Schedule 1 is it deals with the list of names of the states and the union territories. That is what they deal with. They deal with what? They deal with the subject matter of the list of states and the union territories. So what are all the list of states and what are all the list of union territories and what are the territories of these states and union territories? So all these things are dealt in Schedule 1 of the Constitution. So you can just open Schedule 1. You will understand that the Schedule 1 contains the names of all the 28 states. It does contain the names of all the 8 union territories today. They not only contain the list of all the states and all the union territories, but apart from that, they also contain the territories of all the states and all the union territories in our country. So this is what is contained in the Schedule 1 of the Constitution. So therefore, if you want to know what is the name of each and every state, that is there in the Schedule 1. The Union Territory's name is also there in the Schedule 1. But what is the source of the Schedule 1 of the Constitution? That is nothing but the Article 1 of the Constitution. Or in other words, the Schedule 1 flows from Article 1 in the Constitution. It is as simple as that, okay? So whenever you create a new state, whenever you reorganize the territories of any state, whenever a new state is established into India under Article 2, when all these things are done, respective changes will also happen in Schedule 1 of the Constitution. So that is also something that you'll have to keep it in your mind. Come to the next schedule, that is Schedule 2 of the Constitution. What is the subject matter of the Schedule 2 of the Constitution? When the Constituent Assembly drafted the Constitution and when the Constitution came into force, they wanted to place a salary and allowances of some of the dignitaries in the Constitution itself. And where they are separately segregated and placed, they are placed in the Schedule 2 of the Constitution. So Schedule 2 of the Constitution gives us the information as to the emoluments and allowances of certain dignitaries. And who are those dignitaries? So it is easy to remember that Schedule 2 deals with the salaries and emoluments and allowances of certain dignitaries. But sometimes the question may extend to who are those dignitaries and whose emoluments are placed in the Schedule 2 of the Constitution. It includes important constitutional dignitaries and certain other dignitaries also, like the President of India, the governors of the state, the head of the Union Executive, the head of the state executive, the presiding officers in case of both Lok Sabha as well as Rajya Sabha, that is the Speaker and the Deputy Speaker, the Chairman and the Deputy Chairman. Similarly, the presiding officers at the state level in the state legislature, the Speaker and the Deputy Speaker of the legislative assemblies, the Chairman and Deputy Chairman of the legislative councils, judges of the Supreme Court, judges of the High Court, and the Comptroller and Auditor General. Now, all these things are specifically given in the Constitution itself. So, their salaries and allowances or their emoluments, they are all mentioned in the Schedule 2 of the Constitution. Just try to remember this. The constitutional heads, the presiding officers of all the legislatures, and then apart from that, the judges of Supreme Court and High Court, and then the Comptroller and Auditor General of India. Only these things are mentioned in the Schedule 2 of the Constitution. So now we'll move to what is called as a Schedule 3 of the Constitution. What is the Schedule 3 of the Constitution is dealing with? Schedule 3 of the Constitution is dealing with the oath and affirmation that has to be done by certain categories of people or certain constitutional and other dignitaries. So what kind of oath it is to be administered to them before they assume the office or under other areas as well. So that is exactly mentioned in the Schedule 3. So in general, remember, Schedule 3 deals with the oath and affirmations. For whom is the question? For all the union ministers. So the union ministers take what is called as a oath of secrecy, and where this oath is mentioned, that is mentioned in the Schedule 3. Candidates for election to parliament who wanted to contest election to the parliament, before contesting election, they should be administered an oath. Usually this oath is administered in front of the returning officer. So what type of oath? It is given in the Schedule 3 of the Constitution. Members of parliament, after they get elected, a oath is administered. Usually this is done by the Speaker pro tem and other authorities. So this is also mentioned in the Schedule 3 of the Constitution. The oath that is to be administered to a judge of a Supreme Court, the oath that is administered to a Comptroller and Auditor General, and the same thing, the ministers at the state level, the candidates for election to the legislature of a state, both through legislative assembly as well as the legislative council, the members of the state legislature, somebody got elected as a member of state legislature, and the judges of High Court. So you may remember, so ministers at both the levels, people who wanted to contest election to parliament or to the state legislature, somebody who got elected to the parliament or state legislature, then the judges of the Supreme Court, the judges of the High Court, and in addition to that, the Comptroller and Auditor General. So for these functionaries, what type of oath is to be administered on various occasions is given in the Schedule 3 of the Constitution. So Schedule 1 is dealing with what? The name of the states and union territories and their respective territories also. Schedule 2 is dealing with the salaries, emoluments and allowances for certain categories of people. Schedule 3 is dealing with the form of oath and affirmation that is to be administered to certain categories of people. Now come to Schedule 4 of the Constitution. If you see the Schedule 4 of the Constitution, the Schedule 4 of the Constitution deals with allocation of seats in the Council of States. So this is what they deal with. Or allocation of seats in the Council of States. The Council of States is nothing but the Rajya Sabha. That means if you go to Schedule 4 of the Constitution, you will have an understanding for every state in our country how many seats has been allocated in the Rajya Sabha. In fact, we know for the state of Uttar Pradesh, which has got the highest number of seats allocated in the Rajya Sabha, and the highest number of seats for Uttar Pradesh is 31. And how do we know that Rajya Sabha has got 31 seats? It is there in the Schedule 4 of the Constitution. Andhra Pradesh has got 11 seats. Telangana has got 7 seats. So how do we get to know all these information? It is mentioned in the Schedule 4 of the Constitution. So all these information is given where? It is given in the Schedule 4, and some of the union territories have also got representation in the Rajya Sabha. That is also mentioned in the Schedule 4 of the Constitution. So this is basically what you will have to understand with regard to Schedule 4. Okay, this is a question to all the students. While the number of seats when it comes to the Rajya Sabha is mentioned in the Schedule 4 of the Constitution, what about the number of seats when it comes to the Lok Sabha? Where is it mentioned? And who is authority to determine number of seats to Lok Sabha from various states? So please put your answers in the comment box. I have already discussed all those things number of times. In case if you are not able to answer this particular question, please go back to my lecture on Parliament and try to get an answer to this particular question. Alright, so come to the next schedule, that is Schedule 5 of the Constitution. Very, very important. Schedule 5 and Schedule 6 is a very, very dear area to UPSC. Most of the times they pick questions from Schedule 5 and Schedule 6 of the Constitution. So what is the Schedule 5 and Schedule 6 of the Constitution? Schedule 5 of the Constitution talks about the administration of the scheduled areas in our country. So what is this administration of scheduled areas? So scheduled areas are those areas which can be declared by the President of India. The President of India, by virtue of the provisions in the Constitution, he can declare any area to be what is called as a scheduled area, provided there is a substantial amount of scheduled tribe population in that particular area. And the President of India is empowered to do this in any state in our country except the state of Assam. There are 4 states which are exempted from this: Assam, Meghalaya, Tripura and Mizoram. These are the 4 states that is exempted in our country: Assam, Meghalaya, Tripura and Mizoram. So these 4 states which is exempted in our country. Apart from these 4 states, that is Assam, Meghalaya, Tripura and Mizoram, in any of the other states in our country where there are a substantial tribal population in a particular area, and that particular area can be declared to be what is called as a scheduled area. And who can do that? It is a president. The president can increase his area, decrease his area, all those things can be done by only the President of India. So again I am repeating it, as per the Constitution, who can declare a particular area to be a scheduled area? It is only the President. In which states he can do that? In all the states except Assam, Meghalaya, Tripura and Mizoram. Can he increase a boundary of the scheduled area? Yes, he can increase it, he can decrease it, all those things can be done. Now, what is the purpose of declaring an area to be a scheduled area? Is once an area is declared as a scheduled area, this area will have certain special features or some advantages which the other areas may not be entitled to. So what happens when an area is declared as a scheduled area? Now, once an area is declared as a scheduled area by the President of India, then in that particular area, as per the Constitution, it is mandated to establish what is called as a Tribal Advisory Council. So this Tribal Advisory Council is like an advisory council, and this advisory council will advise the governor of that particular state as to how that area is to be administered. Although the area can be declared as a scheduled area by the president, but normally the governor will continue to be the constitutional head for that entire state. So therefore the governor will look after the administration of that particular area as well, but based on the advice that is given by the Tribal Advisory Council. And this Tribal Advisory Council predominantly contains members from the tribal population. So there are specific membership that is given, but that is not very important. But try to understand this. So predominantly who will be part of this Tribal Advisory Council? Predominantly it is a people belonging to the tribal population in that particular scheduled area will be part of the Tribal Advisory Council. And they give the advice to the governor, especially with regard to what type of laws made by the parliament and the state legislature may apply in this particular area. That means try to understand, once an area is declared as a scheduled area, the laws made by the parliament and the laws made by the state legislature may not apply directly in this particular area, which is declared as a scheduled area. The law made by the parliament and the law made by the state legislature may apply in this area subject to such modifications that can be done by the governor of that particular state. So the governor can modify the law and the modified version of the law may apply. Sometimes he may say that law may not completely apply also. It is all done by whom? It is all done by the governor of that particular state, but the governor will do this based on the advice that is given by the Tribal Advisory Council, and which is for the purpose the Tribal Advisory Council is established. So this is basically, you will have to keep in your mind. So the applicability of the laws made by parliament and the state legislature depends upon how the governor would allow them to apply in that particular area, and this is majorly based on the advice that is given by the Tribal Advisory Council. So these are the major provisions of the Schedule 5 of the Constitution. The very objective is that the tribal areas, they have a different way of life, so therefore they have to be protected, and hence the laws may apply subject to the modifications that can be done by the governor, which he does based on the advice that is given by the Tribal Advisory Council. In the future, if any amendment is to be brought in to the Schedule 5 of the Constitution, that amendment can be done by the parliament, but that amendment does not require a special majority. Any amendment to any of the provisions in the Schedule 5 of the Constitution can be done by a simple act of parliament, because the Constitution says that any amendment to the Schedule 5 of the Constitution is not deemed to be an amendment under Article 368. So once you say it is not deemed to be an amendment under Article 368, it can be done by a simple majority. So try to remember all those things. So Schedule 5 is basically to protect the people in the scheduled areas, predominantly majorly consists of what is called as the tribal population. And who can declare an area to be a scheduled area in any state? It is the President of India, except Assam, Meghalaya, Tripura and Mizoram. And the governor would specify as to what laws may apply to this particular area subject to such modifications and specifications that can be done by the governor based on the advice that is given by the Tribal Advisory Council. So these are all the things that you'll have to keep it in your mind. So now come to Schedule 6 of the Constitution. While Schedule 5 of the Constitution deals with the administration of scheduled areas, Schedule 6 of the Constitution deals with the administration of tribal areas in our country, only in the states of Assam, Meghalaya, Tripura and Mizoram. So what was not covered in the Schedule 5 is covered under Schedule 6 of the Constitution: Assam, Meghalaya, Tripura and Mizoram. So these are all the states that is covered under what is called as the Schedule 6 of the Constitution. So in these states, wherever there is a significant tribal population, in those areas the Schedule 6 may apply. But before applying the Schedule 6 of the Constitution, we'll have to understand as to what the Schedule 6 says with regard to all those things. What does the Constitution say? In case of Assam, Meghalaya, Tripura and Mizoram, where there is a substantial tribal population in a particular area, and that area can be declared to be what is called as an autonomous district. And who can declare a particular area as an autonomous district where there is a substantial tribal population? The governor of that particular state can declare that particular area to be what is called as an autonomous district. And once it is declared as an autonomous district, only in the states of Assam, Meghalaya, Tripura and Mizoram, that autonomous district has lot of powers. So try to remember this, but this provision applies, as I already said, only in the case of Assam, Meghalaya, Tripura and Mizoram. And who can declare an area to be an autonomous district? It is a governor. In Schedule 5, in scheduled areas are to be declared by the President of India, but here the autonomous district is declared by the governor. Once a particular area is declared to be an autonomous district, there can be what is called as an autonomous district council. This is very, very important. First, district will be established, autonomous district. And within the district, there is an autonomous district council which will be established. And the district council is empowered to make some laws with regard to certain areas under Schedule 6 of the Constitution. Say, for example, with regard to their local customs, their marriage, divorce, property rights. So with regard to all those things, the law made by the parliament or the state legislature may not apply. The law that is brought in by the district council will apply in those areas, because the tribal people do have a different way of life. But of course, the council does not have the power to make laws in all the areas. Certain areas, as I already said, is specified in Schedule 6. In those areas, the law will be made by the district council, and only those laws will apply in these areas. And if in a particular area, if there is a homogeneous tribal population, where largely all the tribal people are from the same tribal community, then there is a district, autonomous district regions, or an autonomous district. And for that autonomous district, you have an autonomous district council. But it might be possible that in a particular district, there are different tribal populations, there are heterogeneous tribal populations. In that particular case, a particular district can be further subdivided into number of regions. And within the region, for every region, there can be an autonomous district council. So this is what you'll have to understand, and the district council will take care of the laws for that particular region, and that law will apply in that particular area. So if the entire district of same tribal population, then there is an autonomous district, and within the autonomous district council. But within the district, if there are multiple tribal population, then the district is further subdivided into autonomous regions, and for every autonomous region, there can be regional council. So this is what basically you will have to understand under Schedule 6 of the Constitution. Now in this case also, the Constitution says that if any amendment is to happen to any provisions of Schedule 6 of the Constitution that is not deemed to be an amendment under Article 368, they can be just done by a simple act of Parliament. So that's basically what you'll have to understand even in case of Schedule 6. So if you primarily see the difference between Schedule 5 and Schedule 6, while Schedule 5 is talking about scheduled areas, primarily the tribal population, not necessarily only the tribal population, but primarily tribal population in all the states in India except Assam, Meghalaya, Tripura and Mizoram. Whereas the Schedule 6 talks about autonomous districts in case of only Assam, Meghalaya, Tripura and Mizoram, where there are only tribal populations. Where in case of Schedule 5, the President can declare an area to be a scheduled area. In case of Schedule 6, who can declare a particular district to be an autonomous district? It is the governor of the particular state. In Schedule 6 of the Constitution, in Schedule 5 of the Constitution, wherever there is a scheduled area, there is a tribal advisory council. And in Schedule 6 of the Constitution, wherever there is an autonomous district, there is an autonomous district council. And in both the cases, both in Schedule 5 and Schedule 6, if at all any amendment is to be brought into these schedules, they can be done by a simple act of Parliament. That is, they are not deemed to be an amendment under the Constitution of India. They are not deemed to be an amendment under Article 368 of the Constitution. That means they do not require what is called as a special majority. They can be done by a simple act of Parliament. Please come to the next schedule, that is Schedule 7 of the Constitution. Very simple. Schedule 7 of the Constitution talks about the distribution of subject matters. In fact, if you go to the Schedule 7, you will understand that there are 3 lists given in the Schedule 7 of the Constitution. And what are the 3 schedules? What are the 3 lists? The union list, the state list and the concurrent list. The union list is going to talk about the subject matters where only the Parliament can make laws. The state list, which is a list 2, which talks about the subject matters where normally only the state legislature can make laws. And then there is something which is called as list 3, which is the concurrent list. This is a list where both the Parliament and the state legislature can make laws. So these are the 3 lists that is given in the Constitution of India, and all the 3 lists are now given mentioned in the Schedule 7 of the Constitution. Any amendment that is done to the Schedule 7 of the Constitution, it can be done only by a constitutional amendment under Article 368. So when I say it can be done only under constitutional amendment under Article 368, it requires a special majority. So here the special majority is required not only in both the houses of the Parliament, but it also requires ratification by not less than at least half of the states. So not less than half of the states shall also ratify. So do you know why at least not less than half of the state legislature shall also ratify? It is required that at least not less than half of the state legislature shall also ratify them, because any amendment to the Schedule 7 of the Constitution is considered to be an amendment to the federal provisions in the Constitution. So when you amend the federal provisions in the Constitution, it also requires amendment by both this amendment is to be ratified not only by a special majority by both houses of the Parliament, but also by not less than half of the state legislatures. Okay. All the information that I am talking can be asked as a question there in your examination. So therefore it becomes very, very important. The next schedule, in fact the last schedule in the original Constitution, is the 8th schedule, which talks about certain important languages spoken in our country, and these languages are mentioned in the 8th schedule of the Constitution. So presently, how many languages are there? So presently, there are 22 languages that is mentioned in the 8th schedule of the Constitution. So you can quickly go through it if you want. There are 22 languages which is there. But in the original Constitution, there are only 14 languages. So how many languages there in the original Constitution? When the Constitution came into force, there were only 14 languages on 26 January 1950. But then subsequently it increased by first the 21st Constitutional Amendment Act, one further language was added. So therefore making it to 15. And again by the 71st Constitutional Amendment Act, I think they added 3 more languages. And then by the 92nd Constitutional Amendment Act, they added 4 more languages. So therefore today, if you add all those things, it has now become to 22 languages. It's easy to remember. If you add 21 plus 71, it becomes 92. So 21st Amendment, 71st Amendment, so therefore 92nd Amendment also. Sometimes I can ask you specifically the languages also. So for example, 21st Amendment. So 21st Amendment inserted what is called as Sindhi into it. So 21st Amendment. And then you have 92nd Amendment. I'll just come to the 71st Amendment. So 92nd Amendment added Bodo. They ordered Dogri. So this is by 92nd. This is by 92nd. And then apart from that, they also added what is called as Shantali was added by the 92nd. And they ordered also what is called as Maithili. So all these things were added by the 92nd Amendment. And then you have the 71st Amendment also. Konkani was added by the 71st Amendment. Manipuri was added by the 71st Amendment. And Nepali was added by the 71st Amendment. So therefore, you can also make a note, 21st Amendment, Sindhi was added. 71st Amendment, Konkani, Manipuri and Nepali was added. And 92nd Amendment, Bodo, Dogri, Shantali and Maithili, all these languages are added. So sometimes it can be asked in the prelims examination. What are the amendments related to the 8th schedule of the Constitution? 3 amendments. And of course, what are the languages that was added? These are the languages that was added. So these are all some of the things that you'll have to keep it in your mind. Alright, so with that, we'll proceed further to the 9th schedule of the Constitution, which was inserted by the first Constitutional Amendment Act in 1951. Now, what is the objective of this 9th schedule of the Constitution and what is the source of this 9th schedule of the Constitution? It is Article 31B, which is the source of the Schedule 9 of the Constitution. What is Article 31B saying? Article 31B is saying any law which is made by the Parliament or by the state legislature, it does not matter. So once a law is made, when I say law made by the Parliament or state legislature, an ordinary law. So if an ordinary law is either made by the Parliament or by the state legislature, and if this ordinary law is placed inside the 9th schedule of the Constitution, then this law which is placed inside the 9th schedule, this will have what is called as blanket immunity. That was the original provision. When I say it will have blanket immunity, that means this law that is placed inside the 9th schedule cannot be judicially reviewed in a court of law. The law cannot be reviewed even if it is in violation of the Constitution or in violation of fundamental rights. It cannot be reviewed and it can be declared to be invalid by the Supreme Court. That was how the strong provision was placed into the Constitution by inserting the Article 31B and Schedule 9 of the Constitution. But however, today this is not the situation, but initially it was a situation. So however, what has happened over a period of time, especially after the IR Coelho case. After the IR Coelho case in 2007, so this was held by the Supreme Court, that any law that is placed inside the 9th schedule after the IR Coelho case is not having blanket immunity, but it is subject to what is called as judicial review. And what is the ground on which they can be judicially reviewed? So they can be judicially reviewed on the grounds that they are violation of the basic structure in the Constitution. That means, even though a law is placed inside the 9th schedule, they can be still reviewed by the judiciary. And what is the ground on which they can be reviewed by the judiciary? They can be reviewed by the judiciary on the ground that they are violation of the basic structure of the Constitution. That means, if any law that is placed inside the 9th schedule, if they are violative of the basic structure, they can be judicially reviewed. And today, presently, what are the laws that can be reviewed? Any law that is placed inside the 9th schedule on or after 24th April 1973. So on or after 24th April 1973, any law that is placed inside the 9th schedule can be challenged on the grounds of the basic structure doctrine. So therefore, to say today the laws placed inside the 9th schedule have blanket immunity, that is wrong. The laws placed inside the 9th schedule can be challenged in a court of law. But what is the ground on which they can be challenged in a court of law? On the ground that they are violative of basic structure. And which laws placed inside the 9th schedule can be challenged? Any law that is placed inside the 9th schedule on or after 24th April 1973. So this is basically what you'll have to understand. Please come to the next next schedule, that is the 10th schedule of the Constitution, very, very important. So again, the 10th schedule of the Constitution elaborately deals with regard to the anti-defection law. And when was this 10th schedule was inserted into the Constitution? The 10th schedule was inserted by the 52nd Constitutional Amendment Act in 1985, and it provides as to what is the ground on which the defection law can apply. In fact, it provides for 4 grounds. Anybody who voluntarily gives up the party membership, anybody who abstain from party directions or vote contrary to party direction, if an independent candidate is there, if an independent candidate joins any of the other party, and if there's a nominated member, and if that nominated member joins any of the other party after 6 months after his nomination, these are all the grounds for their disqualification under the anti-defection law. And who is liable to disqualify them? The presiding officers of the respective house, the speaker or the chairman of the Rajya Sabha, they have the disqualifying authority. And subsequent to their decision, it can be challenged in a court of law. So this is basically what is dealt under the Schedule 10 of the Constitution. So basically, it is a ground for disqualification if the members of the parliament engages in what is called as defection. I have elaborately dealt about this when I was dealing with the disqualification of the members of the parliament earlier itself. You can go back to my parliament chapter and see that, but the basic information, if at all they are going to ask a question from schedule, they can ask you that which schedule deals with the anti-defection law and which year it was brought in. And subsequently, this 10th schedule was also amended by the 91st Constitutional Amendment Act in 2003, where they have changed the 1/3 split to what is called as 2/3 merger as an exception to the anti-defection law. So these are all some information, probably you can keep it in your mind, all right. So with that, you please come to the next article, that is Schedule 11 of the Constitution. So in certain schedules during discussion, I mentioned some articles also, which means these are all the source of the particular schedules. That's the understanding you should have. Similarly, if you see the Schedule 11 of the Constitution, the Schedule 11 of the Constitution was inserted by what? The Schedule 11 of the Constitution was inserted by the 73rd Constitutional Amendment Act in 1992, which provides for basically what is called as 29 functional items like agriculture, fisheries and all those things. So basically, what does it mean by these functional items? These are nothing but these are all the areas on which the state legislature can confer the authority upon the particular panchayat. So the very idea of creating the local bodies is to delegate them some power. So what are the areas on which the state legislature by a law can delegate the power to the local bodies is only on the functional items which is mentioned in the Schedule 11 of the Constitution. So that's exactly what you'll have to understand. Now similarly, the 74th Constitutional Amendment Act 1992 has inserted what is called as the Schedule 12 of the Constitution. And the Schedule 12 of the Constitution deals with what is called as 18 functional items. So what is the understanding you should have with regard to the Schedule 12 of the Constitution or the 18 functional items? The Schedule 12 of the Constitution talks about what? The Schedule 12 of the Constitution contains certain functional items, and these are all the areas on which, if at all any function is to be delegated to the municipalities, it can be given by the concerned state legislature. So that's the basic understanding you should have. Otherwise, they are not very deep question that comes from the schedule, but at least you should know as to what every schedule deals with. Schedule 1, Union and its territories. Schedule 2, dealings with what is called as emoluments and allowances. Schedule 3, oath and affirmation. Schedule 4, seats allocated to the Rajya Sabha. Schedule 5 talks about the scheduled areas in our country. Schedule 6 talks about the tribal areas in the case of Assam, Meghalaya, Tripura and Mizoram. Schedule 7 talks about what? Schedule 7 is all about the subject matters which is related to union list, state list and concurrent list. Schedule 8 talks about certain languages, and Schedule 9 talks about the 9th schedule of the Constitution. Sorry, Schedule 9 talks about the laws that is placed inside the 9th schedule having judicial immunity. Sorry. Schedule 10 talks about what? Schedule 10 is about the anti-defection law. Schedule 11 is about the functional items to panchayat. and schedule 12 is about the functional items to municipalities. So with that, we are almost coming to the end of the discussion of schedules. Just one practice question before we complete this. Which of the following schedule was inserted by the first Constitutional Amendment Act? So which amendment or which the first Constitutional Amendment Act has inserted which schedule? Schedule 8, 9, 10, none. So please put your answers in the comment box. With that, we are coming to another end of another important topic. This is schedules. But in the next lecture, I'll deal with the important amendments to the Constitution of India, because UPSC also asks questions from the important amendments. Before I discuss about the important amendments, can anyone tell me so far? So this video is recorded in the month of April 2025. By April 2025, how many amendments have happened to the Constitution of India? If you know the answer, put it in the comment box. I'll not discuss each and every amendment, but I'll discuss some significant and important amendments in the next class. All right. So thank you very much. With that, I'll wind up this particular lecture. If you have any queries, you can reach out to me through my Instagram account or through my Telegram channel. And if you have any queries, you can please reach out to me. You can think me as a friend, mentor, guide, whatever it is. But I am someone who can help you in clearing this particular examination. Thank you very much and all the very best.